So before we begin and I hand over to Mitchell, we would like to acknowledge the traditional owners of the lands from which we're broadcasting today. I'm broadcasting from the land of the Gadigal people of the Eora Nation today. We pay our respects to elders of the land, past, oh, excuse me, I've just accidentally scrolled through the webinar. We pay our respects to elders of the land, past and present, and we extend that respect to Aboriginal and Torres Strait Islander people attending today's webinar or watching the recording. So as I said, welcome to this legal aid webinar on strata issues for older people. My name is Bridget Barker and I'm from the Community Legal Education branch at Legal Aid New South Wales. Today's session will take an hour and a half in total, and that includes time for question and answers at the end. After the webinar, you will receive an evaluation survey and we really appreciate your feedback. You'll also receive an email with information about the resources that we might talk about in the webinar today. In today's webinar, we'll be talking about strata law in New South Wales and services available in New South Wales. So if you're joining us from another state, these laws may not apply to you. The laws in your state and available services may differ. So I would like to introduce you to Mitchell Harvey from the Seniors Rights Service, who will be presenting to you today. Thanks, Mitchell.
Thanks very much, Bridget. All right, so as we've indicated, the first thing we like to do at the start of these presentations is just to give you everyone here a bit of a rundown about who Seniors Rights Service is and what we do. So very much like many of our sister organisations, SRS is a community legal centre. Just having a little bit of trouble moving across slides there. There we go, that's better. So as I said, we're a community legal centre, which means we're a free legal service and we provide advice and assistance, as well as other services like education and advocacy. We provide that to seniors throughout New South Wales. What that means to us is that for our general services, we are able to assist anybody that's the age of 65 years or older. And we also allow our services to persons who are Aboriginal or Torres Strait Islander who are over the age of 50 years. It can be a little bit complex sometimes, but for all intents and purposes, it does appear on our website. And it is largely 65 and older, particularly those who are in receipt of the aged pension. So we're a pretty broad-based service. We're a specialist service insofar as most of our experience and expertise is in areas that are going to be more specific to seniors. So we deal with a lot of things like aged care advocacy, and that's for people who are in the residential accommodation settings or retirement homes. We also provide services on strata law, which of course is the subject of today's presentation, consumer rights and consumer laws, human rights such as discrimination, elder abuse issues including domestic violence, financial exploitation, and more general advice and information on planning ahead for later life. I always enjoy that because it's actually much quicker for us just to list the things we don't advise about. They are few and far between. Personal injury, defamation, and property or conveyancing is really probably the three key areas that we just aren't able to advise on, as well as complaints about professionals such as other solicitors. Oops, just jumping straight ahead there by accident. So seniors' rights, we are free, we're confidential, and we are independent. So while we might be funded by government organisations such as the Office of Fair Trading for my particular service, we do operate independently of them. So I'm just having a little bit of a lag between when I'm clicking on and when it's changing my slides. That might just be a fun quirk of today's internet. So the Strata Legal Service in particular, I might just go straight to because that's what we're all here for today. So we're able to provide anywhere from advice, information, and advocacy, as well as community education, such as today's session, for older people who are living in strata units or townhouses. And we advise across pretty much any aspect of strata living. So the scheme, this particular project, the Strata Assistance Project was established in conjunction with Marrickville Legal Centre and the Office of Fair Trading way back in about 2016. And it was established largely in relation to the new collective sale and renewal laws. But when we got out in our first tour of New South Wales, got our boots on the ground, we found out that people had a lot of questions about strata and strata living. So the Office of Fair Trading was gracious enough to allow us to expand our service from just advising on collective sales and renewals to advising on pretty much every area of strata. So that's been really good. Just waiting for the slide to turn. So strata laws in New South Wales are effectively governed by 4 key acts and regulations. The Strata Schemes Development Act, Development Regulation, the Management Act and the Management Regulation. For most people who aren't really involved in sort of the establishment of strata schemes or essentially property development, the one that you're really going to be mostly concerned about would be the Strata Schemes Management Act and the Strata Schemes Management Regulation. As a fun little tidbit I always like to raise, the Strata Schemes Management Act is in fact the second most accessed piece of legislation in New South Wales, second only to the Crimes Act. So if that doesn't tell you that people are really wondering, what are my rights, what are my responsibilities under strata, I do think that it's certainly an area of law where it can be quite difficult to navigate. And I'm really hoping that Seniors' Rights Service, as well as Marrickville, are able to assist people navigate their way through these acts and regulations. So today we're only able to provide information and education. Even at the question session at the end, I won't be able to provide anybody with legal advice. That's just because this is a CLE session and any kind of direct advice really does need to go through on a case-by-case basis to your own individual solicitor. So if you're over 65, that'll be the Seniors' Rights Service for free assistance. Under 65, you can always give Marrickville Legal Centre a call. Okay. So we've got quite a lot to get through today, but one of the more, I think, critical areas for people to understand is bylaws. So the bylaws of a strata scheme are a little bit like, I suppose, council regulations. And in fact, strata is often referred to as the 4th branch of government. You've got your federal government, your state government, your local council. And for an increasing number of us, you also have that 4th tier of regulation, which is your strata scheme. So all schemes have their own sets of bylaws, and these are basically rules that owners and tenants, including visitors, must follow. These usually go to deal with issues relating to behaviour and usage of common property. They do impose a legal obligation, so they must be registered. And it is really important if you are thinking about buying a scheme or if you're currently living a scheme to have a copy of those bylaws and to really understand what those rights and responsibilities are. So the model bylaws are effectively just some bylaws that are in the legislation. And those bylaws are usually put in place where the scheme doesn't have any bylaws itself to specifically address some common issues. Bylaws, and I make the joke that contrary to some people's opinions, aren't just whatever we feel like from time to time. There are some restrictions on what bylaws can and can't be. The most notable restrictions are effectively under Section 136 of the Act, that bylaws cannot conflict with another law. In particular, they can't conflict with the Strata Schemes Management Act. And a more recent development is that under Section 150, if a bylaw operates to be harsh, unconscionable, or oppressive, it means that somebody can actually bring a matter to the tribunal to have that bylaw declared invalid. And the most notable example of that one, probably in recent years, has been those blanket bans on pets that you often see. And it's for that reason, I think, that Section 150 is still something that hasn't received a great deal of consideration in the courts and tribunals, but it's definitely something I reckon we're going to be seeing a lot of in the coming years. So one of the most important things to have a look into if you are dissatisfied with bylaws, or maybe you're happy with your bylaws and don't want them to change, is that they need to be changed by way of a special resolution. It's impossible to simply have the Strata committee, for example, change bylaws. You can't just have the Strata managing agent imposing new bylaws. Anytime a special resolution is required in a Strata management scheme, it needs to go to a vote of the whole of the owners corporation. Following that vote, if 75% or more people agree that the bylaw should be changed, then typically speaking, the Strata committee or the Strata managing agent will arrange for its registration through the Land Registry Services. After that, it is a registered bylaw and it will be quite binding on everybody within the scheme. So some of the big updates in the bylaw areas, I'm sure this is probably going to be a few questions because it's still some pretty misunderstood sections or some misunderstood bits of law, is that sections 137A and 137B were introduced. One of the very frequent inquiries we get at SRS, and I'm sure other services are the same, is can we impose bylaws to restrict people using their properties as an Airbnb? And until about last year, the answer to that would have been no. However, the new section 137A does allow a scheme now to introduce bylaws to restrict the use of an Airbnb where the property is not being used as a principal place of residence. What does that mean in practice? Well, effectively it's this. You can still have your Airbnbs, but not where it's just an Airbnb. For a bylaw to restrict somebody using their property as an Airbnb, it could only do so where they aren't also using that place as a principal place of residence. Effectively, it's a new sort of change to try and stop people from turning entire swathes or entire floors of apartments into de facto hotels. So I think in that respect, it's probably a pretty reasonable balance that's been struck between people who would like to earn a bit of extra cash and people who are trying to make a strata scheme their home. One of the other changes that I'm particularly a fan of as a bit of a pet lover is that 137B makes any bylaws which were already in place that are essentially blanket bans, those will now be invalid. The key term to be taking away from this particular section, though, is whether or not the new bylaws unreasonably restrict pets. Typically speaking, it'll be an unreasonable restriction if the bylaws just impose a blanket ban on any and all pets. We're yet to really see what that looks like in practice to some extent. I would generally suggest, though, that a bylaw banning all goldfish would probably be invalid, whereas a bylaw that bans, say, dogs might be ruled on a case-by-case basis to be valid, provided there's checks and balances in place. And it's also noted that in the replaceable bylaws, those are those ones in, say, Schedule 2 and Schedule 3 of the regulations. Under those bylaws, the usual course of action would be that the owner who wants to have their pet would usually need to seek approval, typically of the owner's corporation or the strata committee, prior to the pet coming onto the property. And from there, once the approval is given, everyone just goes their own separate ways. Everyone's happy, we hope. So one of the more common inquiries we get is what to do as a lot owner about a breach of bylaws, and also what to do as, say, a strata managing agent or an owner's corporation if somebody's in breach of the bylaws. I'd point out that SRS unfortunately isn't able to advise owners corporations, and we don't advise strata managing agents. So whenever we see some of these matters, there is a process to be followed. Ideally, the owner's corporation or the managing agent should be discussing a breach of bylaws with an individual, just about that behavior, whether it's, say, bringing animals onto the common property and not adequately cleaning up after them, putting rubbish where it doesn't belong, obstructing the common property, parking in visitors' spaces. Some schemes have a lot of bylaws, some schemes have very few. But if there is a breach, and particularly if it's an ongoing breach, as a lot owner, you might find yourself being issued with a notice to comply with a bylaw. And anytime you get a notice to comply with a bylaw that you disagree with, this would be the ideal time to probably seek a little bit of advice from us or one of our sister organizations about what your options might be. So for the notice to be valid, for instance, it must contain a copy of the specified bylaw that you're apparently in breach of. And the notice to comply is binding on you for a period of 12 months after you receive it. What that effectively means is that if you're in further breach of those bylaws as a lot owner or as a visitor or as a tenant, if you do that again within 12 months, then you'll likely be taken to the New South Wales Civil and Administrative Tribunal. And this is pretty important because the New South Wales Civil and Administrative Tribunal now has the power, the same almost as a local court would, to issue a penalty against an owner or an invitee, etc., who is still in breach of those bylaws. Importantly, unlike in previous bygone eras, that's not now paid to the state government. Under the new legislation, under the new arrangements, anytime the owner's corporation is successful in having one of its somebody in breach fined, what happens now is that that money is paid into the administrative fund for the scheme. And it's designed effectively, just as you'd expect any fine, it's to stop further and recurrent breaches of those bylaws. Because if the conduct does continue, NCAT also has the power, if it's fined somebody within the last 12 months, it has the power, if they continue to breach that bylaw, to double the penalty to $2,200. So it can get pretty serious pretty fast. Again, if you are issued with a notice to comply, or in particular, if as a lot owner, for instance, you're being taken to the tribunal, I would certainly suggest seeking some legal advice about that particular situation. Again, another very common inquiry we get, and this is probably a source of quite a lot of dispute between various lot owners, and in particular the strata managing agents, the owners corporation itself, is the question of repairs. Repairs can be a bit tricky, mostly because finding out what is and isn't common property can be a little bit hard to determine. But in all matters, the owners corporation has what's known as a statutory duty or a statutory responsibility to ensure that it maintains and repairs the common property. Some common inquiries we get are things like upkeep of gardens, upkeep of roof gutters, etc. And it's important to make sure these things are maintained as a strata or an owner's corporation, because if the owner's corporation is found to have failed in this statutory duty to maintain the common property, a lot owner can actually seek redress through the tribunal. A good example is things like waterproofing. Say you have a deck or something like that, or that you're the top floor unit and the roof is common property. If the owner's corporation doesn't maintain that roof, then you can take the owner's corporation as a lot owner to the tribunal to seek compensation for any kind of damage that's happened in your lot because of the failure to maintain the common property. One of the critical things about common property and the duty to maintain common property, of course, is that a statutory duty is something that the owner's corporation must take seriously. It has an active duty to maintain and repair the common property. It's not necessarily up to lot owners to notify the owner's corporation of issues with the common property. It's always an active, ongoing thing for the owner's corporation to make sure it's aware of any potential problems with its own common property. But that takes us to what is common property. And this is really a foundational question. It differs from scheme to scheme. It can differ wildly from scheme to scheme, quite frankly. But there are some fairly general rules that are pretty common across all schemes. I like to always suggest to people, no matter what's on our page here, that the best way to think of a lot or an apartment in a strata scheme is essentially like a very nice shoebox. Effectively, what's going to be lot property is anything that's inside that shoebox. So that's the upper surface of the floor, but not the carpet typically, the undersurface of the ceiling, all external or boundary walls, including doors and windows. That's a pretty good idea of where the common property boundaries are going to be. But common property can also include such things, often on a case-by-case basis, such as any pipe that services one or more lots, electrical wiring, any originally installed parquet floors, ceramic tiles, floorboards, vermiculite ceilings, plaster ceilings and cornices. Balcony doors are a bit of a contentious one because they have changed quite a bit since 1974. And mostly and in particular, the slab that divides two stories of the same lot, even if it's enclosed entirely within a single lot. So it's important to really get a very good grasp of exactly what is and isn't common property, because common property can be made common property by way of numerous different things. Number one is the registered scheme. So anytime you go and get a copy of your Strata scheme, you will see that there's some thick lines, there's some thin lines, there's some broken lines, various other ways of looking at the plan to figure out what is and isn't common property. And there can also be certain notations on that scheme too. So if you do find yourself in a dispute with, say, the Strata managing agent and the owners corporation about if this is your responsibility or a common property and therefore owners corporation responsibility, it's a very good idea to go and get some legal advice about how to adequately or properly interpret your Strata plan, because I have seen some ones in practice that have been, let's put it this way, not normal. But whatever's registered on the scheme is what will be binding. It is what's going to actually determine common property from lot property. There's also other ways of looking at it, such as the common property memorandum. The common property memorandum is effectively a list of things that's been established by the regulations that really goes through to try and basically let people be more aware of what is and isn't common property in any particular scheme. So typically, if your scheme has a common property memorandum, that'll be there in the bylaws, because there's another way of dealing with common property, and we're going to get to that very soon. So I think we've probably been over section 106. The only one I think I'd really add to that is that if you do find yourself with damage to your lot because of the owners corporation's failure to maintain the common property, you really need to try and take some kind of action under this section within 2 years that you first became aware of the loss. If you try and bring an action outside of that, it does become a lot more difficult, as you might no longer have the benefit of section 106 of the Act. Preparing for NCAT, we are going to be touching on this one from time to time throughout the course of this presentation, because it is a very common issue in the tribunal, that there are processes that need to be followed. So first and foremost, you should notify the owners corporation that it's in breach of its duty to repair in writing. So you write to the secretary, you write to the chairperson, you write to the managing agent. And it's always good to have these things in writing. Otherwise, they are largely just difficult matters to prove to the tribunal that has been adequate notice given. It's always a good idea to maintain those records of communication, because it will come up at the tribunal. You should definitely maintain records of all loss. So economic loss, and in some circumstances also non-economic loss. And that can even be for things like personal injury. After that, typically, if the breach of that duty to maintain the common property has not been rectified, the first port of call is to apply to the Department of Fair Trading for a mediation. Mediations are not mandatory. It's up to the owners corporation and the Strata managing agent, who would usually be there at the mediation, as to whether or not they want to attend. But you at least need to apply for the mediation. Because if the mediation is unsuccessful, you can then apply to the New South Wales Civil and Administrative Tribunal for orders under the Act to settle those disputes. But in terms of getting those orders, you'll always need to show the tribunal that you've been through the mediation process, even if it's unsuccessful. Renovations are another matter that I think causes quite a few issues between lot owners, particularly adjacent lot owners. And that's because renovations are really one of those items that isn't particularly well understood in terms of what everyone's rights and responsibilities are. Thankfully, the new Act, I think, really did understand the difficulties faced by both the tribunal, by lot owners and by owners corporations under the previous legislation. And it's introduced some new, I suppose, definitions. It used to, in fact, be the case that if you wanted to put a thumbtack in a wall, you would have needed to seek the owners corporation's approval. That was a little bit absurd and a little bit onerous, both for lot owners as well as for the owners corporations themselves to deal with, frankly, a myriad requests that weren't really about much more than thumbtacks or just painting the inside of your own apartment. So to try and resolve that, Section 109 is now in force, has been for some time. And 109 deals with cosmetic renovations. These are really renovations that are very minor in nature and don't require the approval of the owner's corporation in any way, shape, or form. It'll be things like installing or replacing hooks, nails, screws for hanging paintings, etc., on walls, particularly common property walls where it's the internal facade. So I'm not saying go out there and start driving dead bolts into the common property outside, but in terms of putting a hook or a nail to hang a painting in your own apartment, generally speaking, I can't think of many reasons that won't be okay, unless you're, of course, a tenant. There's also installing and replacing handrails, which is particularly important in my work. Painting, filling minor holes and cracks in internal walls, laying carpet, and we will broach that topic a little bit more shortly. Installing and replacing built-in wardrobes, installing and replacing internal blinds and curtains, or in fact, any other work prescribed by the regulations for the purposes of this subsection. And it's not really too much more, but you get a bit of an idea, I think, from that list there as to what the likely things are that are going to be included. Now, the number one here is probably, the number one contentious one here is probably going to be the laying of carpet. Because under Section 110, this is minor renovations. And a minor renovation does still require the approval of the owner's corporation. And it has to be given by way of a general resolution, which means 50% of all owners. But that does mean, because it's only a general resolution thing, it can actually be delegated to the Strata committee and or the Strata managing agent. That'll be things like renovating a kitchen, changing recessed light fittings, installing and replacing wood or other hard floors, installing and replacing wiring or other cabling, power and access points, work done to reconfigure internal walls that's not, say, a load-bearing wall, or again, any other work prescribed by the regulations. A really good rule of thumb that I've found in practice for figuring out the difference between a minor renovation and a cosmetic renovation is really to ask yourself, should I be doing this myself? For instance, I don't think I'm going to have a good time renovating a kitchen by myself, but I'm really hopeful that I could at least probably install or replace a hook in my own apartment. Anything that requires a licensed contractor or should be done by a licensed contractor is likely to be at the very least a minor renovation. But again, if it does result in a dispute between yourself as a lot owner and the owner's corporation, it's best just to call up, seek some quick legal advice about where you stand. The final and third category, which you might have guessed, is the most major category, and those are going to be aptly named major renovations. These are things that aren't cosmetic and aren't minor. And basically, that is any works which adversely or majorly affect the common property. These do require a special resolution, and the special resolution really does, again, need to be passed by 75% of all owners, and it might also be accompanied by a common property rights bylaw. Major renovations are things such as work that involves structural changes, reconfiguring internal walls of a major nature that aren't just standing or floating walls, work that changes the external appearance of a lot, such as installing an external access ramp, work that involves substantial amounts of waterproofing. You might have a deck or something like that. If the decking does involve effectively waterproofing to prevent water going between your lot and the lot below, that's going to be a major renovation. Anytime you need to approach council to do something, again, major. So these are things, I think, more in a nutshell to think of where they're huge deals. These are usually works that involve thousands of dollars outlaid for the works themselves. They might involve planning approvals, and they definitely involve getting it properly approved by the owner's corporation as a whole, not just the strata committee, not just the strata managing agent. The next one really to have a look at in here is what's known as a common property rights bylaw. So there's a couple of different ways that a lot owner might use the common property for their own benefit. One is under just a regular license. A license, though, does require a special resolution, and a license might be granted to a lot owner under the circumstances where they probably need to use the common property to benefit their own lot, but they don't intend to have exclusive use, or they don't intend to exclusively occupy the common property. Good examples here would be shared storage cupboards that are located on common property that might be shared across multiple lots. It could be a license for whatever reason for one lot to use a parking space on common property, maybe because their own car space can't be used without causing an obstruction. Again, if you are looking to get a license over the common property, legal advice, first and foremost, is a good idea. The second and more permanent category of common property usage is where a common property rights bylaw is required. This is usually going to be in circumstances where a single lot intends to permanently and exclusively use the common property. Common examples, again, are car spaces, where that car space is effectively registered to the lot, but it can also include much more minor things that still do really need that assistance by the common property rights sections. Installing a split system air conditioner is a very common example. Installing pretty much anything on the common property that's the exclusive use of your lot, you are going to need a common property rights bylaw. Most managing agents are probably going to be perfectly happy and able to assist you with this, should you want to install an air conditioning unit on your balcony or something like that. One of the best things I could ever advise you in Strata would always just be to try and work as best as you can with your Strata committee, with the owners corporation in general, and also with the Strata managing agents. So one of the most recent updates that's only come in quite recently in relation to these common property issues and changes to common property are the new sections, sections 5, section 132A and section 132B. This is really a couple of different bits of new legislation that have been brought in by the state government to try and encourage strata schemes themselves to take up more sustainability infrastructure. And what's pretty much meant by that is things like solar panels, maybe even a wind turbine, depending on planning and how it looks, etc. Various other things that are intended to assist the owners corporation, or sometimes even individual lots, maybe in smaller schemes, to really bring in those energy efficiency measures and renewable energy measures. The biggest change in these sorts of, the biggest change that's been created by these sections effectively is really that, unlike normal changes to common property, which require special resolutions for any and all changes, the new legislation states that the special resolution still needs to go to a vote of all the owners, but the owners corporation only needs to resolve in favor of it with 50 or more percent, rather than the 75% required for regular changes. This is really intended also to, I guess, future-proof New South Wales, because we are seeing quite a lot of strata schemes installing EV charging stations on the common property, solar panels on the roofs to offset rising energy costs for bills incurred by the common property for lighting, for pools, etc. And the hope, I suppose, is that this will assist owners corporations getting those changes through to try and help everybody with lower strata fees, lower bills, etc. Okay, moving along, contributions and levies. Again, these are some of the more common inquiries we get because they can be, I think, a little bit controversial from time to time. But I think a lot of the controversy can really just arise from inadequate explanations or misunderstandings. There's very few matters I've seen in practice where contributions or levies have been unlawfully imposed, but it does happen from time to time. Oops, just gone the wrong way for some reason there. I do apologize. So the first bit of advice I'm going to give everybody is, even if you're in dispute with the owner's corporation about the legality of a levy, the fairness of a levy, or whatever else, it is never, ever a good idea to simply withhold your levies. As part of living in Strata, you need to pay your quarterly levies for general maintenance of upkeep. That includes the administration costs, as well as any special level levies that might be raised from time to time by the owner's corporation. Special levies are effectively levies that have been raised to deal with unexpected problems, such as repairs that are going to be very expensive, such as just other things that might be outside the scope of the normal way you can plan for eventualities in strata schemes. It could be legal fees, but the most common one realistically is going to be unexpectedly large repairs to the common property. There's probably not too many people in this meeting at the moment, in this education, that aren't aware of some of the problems that have been seen in Sydney and Newcastle in relation to some of the newer schemes that have just been built only for substantial and significant defects to be discovered. And unfortunately, there's not too much that can be done in some circumstances except to raise what can be extremely distressing and financially quite upsetting special levies. And anytime you do have a question about special levies, first port of call is to raise those questions with the strata managing agent or the committee. And following that, if you're still not able to reach any kind of agreement, or if you're still wondering what your options might be, it's always, again, a good idea to try and get some legal advice about that. Levies that go unpaid are pretty damaging. And that's because under the legislation, they do attract an interest rate of 10% until they're paid. So if they are 1 month or more overdue, then you will need to go and ensure that they're paid ASAP so that you're not incurring, that really big interest rate. Now, the owner's corporation can decide that a debt owed to it doesn't bear any interest. This would usually be pretty appropriate, particularly for seniors' rights service clients, where the reason that the levies haven't been paid is because you might be there on a pension or on a fixed income and just simply unable to afford it. Because the owner's corporation can certainly enter into payment plans with individual lot owners. Special levies in particular aren't a case where the owner's corporation really should be needing to force everyone to pay some big lump sum all up front. And again, I just encourage people to look at getting their own advice should they be faced with a special levy that they're finding it difficult to afford. So another great reason to ensure you're always up to date with your levies, even if you are in dispute with the owner's corporation, is because levies do have an unfortunate habit, once they owe or once they're owed, of spiraling wildly out of control. You may have read an article in the Sydney Morning Herald recently, and I think the Australian picked it up too, that the owners' corporations, many thousands and thousands of owners' corporations in Australia, are now one of the most common parties, that's a party to proceedings, that effectively makes people bankrupt. And it's often for non-payment of levies, and it's often for a non-payment of levy issue that has spiraled completely out of control. Legal fees have been added, and now people are finding themselves seeing maybe $1,000, $2,000 worth of overdue levies, spiraling into tens of thousands of dollars worth of legal costs when the dust settles. The advice I'd always give people, again, is that you need to be very careful. If you're in a dispute about repairs not being done, it is no answer to not paying your levies that you're upset because the owner's corporation hasn't been maintaining the common property. It is a separate issue. It's the same as if I'd advise a tenant about withholding rent from a landlord because of repairs that are going undone or because of any other reason. It's not a matter that is the best way to go about it. And in fact, going that way about it is probably about the worst way you can do it. The owner's corporation does need to give you notice before they go and take action in the local court. But once they've given that notice and waited out the 21-day period, they can pretty much at any time go and seek an order from the court that those fees are payable. And once you then fail to pay a judgment debt, very sadly, unless there's a very good reason for that having happened, it's going to often then result in enforcement proceedings up to and including bankruptcy. The reason I say pay the levies now, dispute it later if at all possible, is because even if there is a dispute about levies and you want to raise that dispute, the better place to do it rather than as a defendant in the local court for unpaid levies is as an applicant to NCAT. That's the New South Wales Civil and Administrative Tribunal. And that's usually seeking an order for the payment of contributions of a different amount or an order for the payment of contributions in a different manner. So what does that mean in practice? That's a good question. Largely section 87(1)(a), and that's the section allowing for payment of contributions in different amounts. That would typically come up in circumstances where it's probably going to be a large scheme, and it might be that the owner's corporation is trying to get a special levy for repairs, but those repairs are really only applicable to a set number of unit owners. Commonly, this would be things like a multiple building strata scheme where a roof has issues, or it could be in relation to a lift that only services a couple of different lots. So in those circumstances, if you do disagree with the imposition of the levies because you don't get any use or service out of that facilities, you are still required to pay them, but you might have some kind of availability to seek variation through NCAT. I imagine that a lot of these matters will probably be coming up in question time at the end, so I won't dwell too much on these ones because they're still pretty tricky. The other one, of course, is probably more useful for people who are financially struggling, and that's an order for the payment of contributions in a different manner. So under a couple of different sections of the Act, if you are struggling financially to pay a special levy or even just recurrent levies that might have gotten a bit out of control, you can apply to the tribunal for an order that the owner's corporation enters into a payment plan with you if the owner's corporation unreasonably refuses to do so. But as with many things that we'll be seeing in our dispute resolution section, you need to at least ask first. Dispute resolution. This is honestly my favorite section because dispute resolution is probably the thing that is the easiest to do and also the thing that's done frequently the least well. There are steps to take in any kind of dispute with the Strata committee, with the owner's corporation, or with the Strata managing agent. First and foremost, I will never charge my clients a fee. And because of that, I always encourage them to exhaust all of your non-legal options before running off to the tribunal or to the court. So just talk about it. Talk about it internally with the secretary or the chairperson. Sometimes that might get you nowhere. And that's fine. From there, if you can't talk about the issues informally, you really need to start that more formal process, which is to write a letter to the Strata committee. You can then look at any kind of internal dispute resolutions if they're available. More often than not, if you're at this point, it's probably around step 2 or 3 that you should start seeking legal advice, because someone is inevitably going to be right and someone's inevitably going to be wrong, and you don't really want to be the one who is wrong. So internal dispute resolution can be helpful, but the number one thing that I really encourage people to do for so many reasons is to simply formally write to the secretary and the Strata managing agent to submit a motion. so that any kind of problem you're having with Strata that can't be resolved by the committee, many things can't, that can't be simply resolved by the Strata managing agent, goes to a motion at the next general meeting to be voted on. The reason I really like to stress point 4 here is because the New South Wales Civil and Administrative Tribunal isn't a court insofar as it doesn't have the broad powers of, say, the New South Wales Supreme Court. NCAT is a pretty informal jurisdiction, but because of that, it only has the powers it has granted to it by the legislation. And so many different sections of the Strata Schemes Management Act do require you to have proposed a motion before NCAT has any authority to make a decision. Because whether it's a dispute about pets being unreasonably refused, whether it's a dispute about repairs not being done, whether it's a dispute about renovations that are necessary for your apartment or your lot that have been unreasonably refused, NCAT will typically only have the power to actually assist you in that, provided that you've already been through the proper process. And that's to submit a motion, even if you know, or even if you suspect that the motion will not go in your favor. You need to submit it anyway, because until you've done that and until you've gotten your answer from the rest of the owners corporation, the tribunal probably doesn't have the power in a lot of circumstances to make the orders that you'd be wanting them to make. So please, please, please submit motions. Again, once the motion's gone and it's not gone in your favor, the first port of call, the first thing to do is to apply through the New South Wales Office of Fair Trading website, seeking a mediation with the owners corporation. If that mediation goes well, and many of them do go well, you can also seek an order from the tribunal that will allow you to effectively get the tribunal to give effect to whatever the mediation agreement was. So you might agree with the owners corporation in that mediation that they'll go and fix the guttering. That's great. If they don't, then you've got your agreement from the tribunal, from the mediation rather. You can then go to NCAT for orders to enforce that agreement. But if it can't be reached that easily, if the owners corporation and yourself as lot owners, as my clients in this situation, are just incapable of resolving those disputes between yourselves, the best thing to do is to look at whether or not the tribunal can resolve that dispute. And it's important to make sure that you consider whether or not the tribunal does have the power to resolve the dispute before going to any of the superior courts. Because if you file in the superior courts, so it could be the Supreme Court, could be the District Court, what have you, and the court finds that the matter could have been dealt with by NCAT, even if you're successful in that court, this is a bit of a tricky one, but even if you're successful, you can actually be ordered to pay the other party's costs. So it's really important through pretty much every stage of this process, rather than just point 1, where you're still dealing with it informally and trying to be your own best advocate, that you do seek legal advice. The tribunal is less formal, as I've said, than the courts are, but it is still a finder of fact at law, which means that there are quite a lot of issues that need to be sorted out and ruled on before the tribunal can go to a final decision. One of these comes up quite often in practice, and that's the issue of what we refer to as standing. So we get a lot of lot owners that are trying to, for instance, get orders for common property to be repaired, but the applicant, while themselves, they might make the respondent the chairperson of the Strata committee. It's important to make sure if you're going to the tribunal, you've got the right respondent and that you're the right applicant. Again, anytime you're faced with these disputes, anytime you're thinking of going to the tribunal, get the advice first before you go, before you file, because it's much, much more easy to sort it out at that stage than it is to have to try and appeal it later. So you've got those sort of steps there. Number 1, try and deal with it informally through the Strata committee. Make sure your request's clear. To submit a motion, it might sound pretty daunting, but it's actually relatively straightforward. Under Schedule 1 of the Strata Schemes Management Act, all you need to do to submit a motion to your owner's corporation is to write to the secretary and the chairperson, identifying yourself by name and by lot, with the motion that you need voted on, as well as a quick explanation under 300 words as to what this motion's all about. So don't be too daunted about submitting motions, but if you are still a little bit unclear about what needs to be done, or if you just want someone to have a look over the motion, please feel free to give Seniors Rights Service a call. Okay. The Office of Fair Trading is a great place to go to get general information about strata living. There's a guide they have available. It looks a bit like this on screen. It's also available electronically. It goes through a little bit about what we went through today. It also goes through a couple of topics that we don't really broach too much. So if you are looking for a copy of that, please give them a ring or jump on the website. It's a really helpful guide to have. There are also some other resources available through Seniors Rights Service, as well as through the Office of Fair Trading, various other loose leaf services that give you a lot of information about strata issues. The tricky part, excuse me, is when all else has failed and you need to apply to the tribunal. Now, I think we're a bit lucky in New South Wales, and I might just be saying this because I'm a lawyer, but I do find that the strata application it's actually quite straightforward. Pretty much you just need to identify, what your strata plan is, the address of the managing agent, and then let the tribunal know what orders you're seeking and why. Because as I've said, the tribunal doesn't necessarily have the same sorts of powers as the superior courts. You might be asking the tribunal to rule on a dispute or make a decision that it unfortunately just doesn't have the power to make. And if you do that, very sadly, from my own experience in my practice, very sadly, when people do that, they can find themselves with pretty nasty costs orders. So again, and I can't stress this enough, if your dispute's gone completely out of control, you can't resolve it, please give us a ring. So if you have a bit of a hunt around on NCAT's website, you might very helpfully find this great little document that used to be attached to the application, but I think is now found as a loose leaf. It's an amazing document. For new solicitors in particular, I pretty much tell them this is your Bible for the next 3-6 months until you really have a good grasp of the Act, because it goes through and really goes and talks about all the different sections that you can seek orders under, what those orders are about, who can apply for those orders, and what else the tribunal requires. Sometimes you won't find what you're looking for on there, but it doesn't mean that it doesn't exist. It's very much just the most common sorts of orders that people are seeking. It deals with things like disputes about common property, disputes about breaches of bylaws, and the very broad sections under, say, 232, which is just a more, as I said, broad-based section that goes through to resolve disputes or settle complaints between a lot owner typically and the owner's corporation. It'll also go through some of the less common orders. That can be things like Section 153 of the Act. Now, Section 153 is known as a nuisance section, and that means that certain lot owners, most lot owners, can seek an order against another lot owner if they're being a bit annoying. So that could be things like extraordinarily loud music at unsociable hours. It could be things like, in particular, smoking that's going between lots. And while these things might be breaches of bylaws as well, sometimes it can be a good idea to try and take a more direct approach. Again, you're looking at filing in the tribunal. Definitely seek some legal advice prior to filing an NCAT. So I'll just note that we are running very much ahead of time at the moment. I've not actually done this presentation in front of such a quiet audience before, and very often where I'm addressing questions throughout. So we are probably going to finish maybe a little bit early, but that just means we have extra time for questions. That's pretty good. Again, first thing to do in Strata Living is arm yourself with the information. So anytime you're in a dispute, you want to make sure that you're in the right of that dispute. So seek some information through those loose leaf services I've mentioned earlier. Get some information through the Office of Fair Trading. And in particular, if it's still difficult to resolve, get some proper legal advice about your specific situation. The lawyers can assist you to do things like interpret the strata plan, apply the legislation, maybe even looking into some case law that might really clear up a couple of those murkier issues, and there are many. Pretty much anything you're going to be looking at, you should always jump through and try and attend mediation first. Mediation through the Office of Fair Trading is thankfully still free. There's no plans to my mind or knowledge to make it not free in the future. And again, I would point out that unless both parties are really running around and being a bit confused as to the state of the law, a lot of matters, if both parties are reasonable, do settle at mediation. So never go into a mediation thinking this is just, a step I have to take and it's not going to settle. You may well find yourself pleasantly surprised. As we're a publicly funded legal service and we are therefore pretty limited in our capacity to assist every single person that calls us, we do encourage people to be their own best advocate. So if you do seek advice from SRS, we are probably going to say to you, that's great, we've given you some advice. If you're wanting to take this matter further, we always encourage people to try and fill in their own Strata applications, send it back to us. Following that, we can then have a look over it to make sure that you've got enough evidence on foot and to make sure that you're seeking the correct orders to resolve the dispute. And we're happy to do that prior to filing. One of the fun quirks about NCAT is that it's much, much, much easier to fix an application that might be a little bit ill-conceived maybe at an early stage, rather than trying to do so at late stages of the proceedings where it might be a bit more difficult, particularly if the evidence that you filed may not necessarily reflect what you need to show at the tribunal. And commonly, this will be things like noise disputes, where it really does often fall down to one party's word against the other, and there may have been some more appropriate avenues. But in everything, it's always a good idea to be prepared for the worst case scenario and just hope for the best. So make sure that you write politely and cordially to your Strata managing agent, your committee, and the owner's corporation at large to try and resolve those disputes. If you can't, follow the process, submitting motions, going through the mediation process through the Office of Fair Trading, and finally ensuring timely and accurate legal advice before going to the New South Wales Civil and Administrative Tribunal is the best and quickest way to resolve these disputes. You don't want to be in a situation where, like unfortunately many people living in Strata, or just many people with legal problems in general, these matters do have an unfortunate habit to remain unresolved even after years and years have passed. I get clients all the time, through no fault of their own, are bringing in documents to me that might be 20 or 30 years old, because that's just how long it's taken for these disputes to be resolved, where to my mind, it's like, well, we need to make sure that a motion goes through, because a motion could resolve these things sometimes. So, as I've said, we're running well and truly ahead of time, because this isn't really a particularly this isn't an in-person presentation, so I'm probably just going through it a little bit on the surface, because I do expect that we're going to get quite a few questions. And as I said, we're always more than happy to answer any questions as best as we can today. Caveat that with the fact that we can't give any legal advice today. But if you are already in dispute and you do need legal advice, please call us on that 1-800 number, or on our alternative number, which is 02 82 9281 rather, 3200. Sorry, 3600. Apologies. Okay, well, that concludes the presentation for now. So I would like to pass back to Ms. Barker, and we'll try and address any questions that we might have from the group. Bridget, over to you.
Thanks so much, Mitchell, for that great presentation. It was very clear and really great information for people. We don't have any questions. I've tried
We
to
don't.
share the link to the Strata Living publication, but and I was able to. I'll just let the audience know. I Googled Strata Living Fair Trading, and that's why I shared the link that I've put into the chat box. But someone's commented that it's not working for them. It seems that Strata resources have moved to the New South Wales government website,
Oh, they have.
and I haven't quite, in the time I've got here, found the particular publication, but I'll just share in the chat box with people. This is where the Strata information is now available on the New South Wales government website, and hopefully that resource is available there. But when I Googled the Strata Living Fair Trading publication, it did come up with the PDF link that I've shared. Perhaps if you Google it yourself, you might be able to actually access that resource directly. So there's a question here for you, Mitchell. Why is your service for seniors 65 and over when seniors in New South Wales are 60 and over?
I can certainly understand the question and where it's coming from, because the concession cards for seniors do indeed start at the age of 60. The reason our service is for seniors 65 and over is because that reflects the funding agreements between us and the Office of Fair Trading. The Seniors' Rights Service as a community legal centre does effectively try and dedicate most of its resources where possible to assist people who are financially not as well off as other members of the community. And in particular, seniors 65 and over is our target demographic, because the overwhelming majority of people who call us are over 65, and they are usually people who are on a fixed income. We aren't effectively under the same arrangements as things like New South Wales through that concession scheme. And again, I'll just make the point that it's just to reflect the funding agreement we have with the people that, let's face it, pay my salary.
Thank you, Mitchell. Someone has raised their hand through the participant box, but I'd just ask you if you wouldn't mind typing, if you have a question, typing it into the question box if you're able to. Because we don't have the ability to take audible questions from people. Lots of thank yous, as you can probably see, Mitchell, for an
That's great
excellent
to hear.
presentation. And just to let people know, I did share a number of resources through the chat box. I will also send an email after today's webinar and attach those resources to the email, as well as the links that were referred to during the presentation today.
I'll also just mention that we do also have a presentation specifically about collective sales and development. We have in the past put that in with the rest of this presentation, but we don't always do that for now, just because we are getting so few inquiries about it. But in particular, if someone does have any questions about collective sales, please give us a call. It's a very complex area of law, but I'm more than happy to address those questions if that's a burning issue for anybody. I think we do have a couple, one more question at the moment.
Yeah, there is a question. Media reports suggest that seniors may be able to have tenants live with them. Will this have strata issues? Good question.
Look, I wouldn't really expect so. The new arrangements, and they are really still, and without any disrespect to the Premier, it does seem that it's pretty much in more of the thought bubble stage. This has been something that's been, I think, on our radar as seniors' rights for a while, particularly as older people do want to remain at home in their own places, and particularly from the other end of the equation, where younger people are finding it more and more difficult to afford proper, safe and secure accommodation. I don't expect that to have any strata issues. I would say it'll be more typical landlord tenant issues that would arise, or potentially owner and boarder issues. We don't have any legislation that I'm able to refer to that would change the current positions, which is that if you are an older person living with somebody else who pays you rent, it's probably going to be a very good idea to try and get some advice about what that actually looks like. They may be a tenant, they may be a boarder, and it's really important at the start of that relationship to establish that. But for all intents and purposes, I don't expect at this stage there to be any problems or any actual considerations with Strata, except if you end up with a bad tenant who plays loud music or smokes. And again, that'd be probably more of a Strata issue that you couldn't have avoided anyway. So no, I don't think there's going to be any major impact that these new arrangements are likely to have on the current state of the law as it already exists with Strata.
Thank you. At this stage, I can't see any further questions, and people have commented that the links I tried to be helpful and share aren't working. So I will double check those and send the links in an email following the presentation, along with attachments, including the handouts that I uploaded into the chat box for the webinar
Bridget.
today. So unless anybody has any last questions, we may just close the webinar off early.
Yeah, a bit of an early mark for everyone, it looks like.
Yeah.
Well, I usually get quite a lot more. I'm hoping the few questions reflects how great the presentation's been for everyone.
That's right. And I can also let people know that the contact email address in the emails that you've received when you registered, cle@legalaid.nsw.gov.au, is an email address that you can send any questions that might occur to you after we close off the webinar. So feel free to send those, and we'll be able to forward them to Mitchell if you're happy with that, Mitchell. To
That's
address them later. There is time if people have any that have occurred, but I think was a lot of clear information, so nobody has attended with burning questions today.
That or everyone's are currently on the phone trying to get some legal advice. Who knows?
That's true. That could be right.
I'd just like to say thank you to everyone who has attended today. It's been a pretty lackluster few years getting out there and doing these talks because of COVID. So it's really nice to get back out here from my own perspective and start talking to the community again through these presentations. And a big thank you to Bridget as well for facilitating that. Thanks, Bridget.
Oh, we really appreciate you making yourself available so that we could run this webinar. And I think a lot of us are hoping to be able to get back into the community and do face-to-face presentations as well.
Absolutely. Okay, well, without any further ado, thank you all for attending. And any questions or any legal advice, please contact Seniors Rights.
Great. Thanks,
Cheers.
Seniors Rights Service, and thanks to all of you from Legal Aid. We'll end now.
Thanks, everyone.